We'll hear argument first this morning in Case 08-1521, McDonald versus the City of Chicago. Mr. Gura.
Mr. Chief Justice, and may it please the Court, although Chicago's ordinances cannot survive faithful application of due process doctrines, there is an even simpler, more essential reason for reversing the lower court's judgment. The Constitution's plain text, as understood by the people that ratified it, mandates this result. In 1868, our nation made a promise to the McDonald family. They and their descendants would henceforth be American citizens. And with American citizenship came the guarantee enshrined in our Constitution that no state could make or enforce any law which shall abridge the privileges or immunities of American citizenship. The rights so guaranteed were not trivial. The Civil War was not fought because states were attacking people on the high seas or blocking access to the Bureau of Engraving and Printing. The rights secured by the 14th Amendment were understood to include the fundamental rights honored by any free government and the personal guarantees of
Of course, this argument is contrary to the slaughterhouse cases, which have been the law for 140 years. It might be simpler, but it's a heavy burden for you to carry to suggest that we ought to overrule that decision.
Your Honor, the slaughterhouse cases should not have any stare decisis effect before the Court. The Court has always found that when a case is extremely wrong, when there is a great consensus that it was simply not decided correctly, especially any constitutional matter, it has less force.
What injustice has been caused by it that we have to remedy? Meaning, states have relied on having no grand juries. States have relied on not having civil trials in certain money cases. They've relied on regulating the use of firearms based on us, the Court, not incorporating the Privileges and Immunities Clause in the way that you identify it. So in which ways has ordered liberty been badly affected?
Justice Sotomayor, states may have grown accustomed to violating the rights of American citizens, but that does not bootstrap those violations into something that is constitutional.
Are you saying that the rights if you could clarify your conception of privileges and immunities, am I right in thinking that to keep and bear arms would be included even if we had no Second Amendment as you envision privileges and immunities?
Justice Ginsburg, that is correct. The framers and the public understood.
Just tell us the dimensions of what it is. I mean, we have the Eighth Amendment, so I know you say that's included. Keep and bear arms would be included even absent the Second Amendment. What unenumerated rights would we be declaring privileges and immunities under your conception of it?
Although it's impossible to give a full list of all the unenumerated rights that might be protected by the Privileges or Immunities Clause, just as it's impossible to do so under the Due Process Clause, at least with respect to the Privileges or Immunities Clause, we have wonderful historical guideposts. There are —
Mr. Gura, do you think it's at all easier to bring the Second Amendment under the Privileges and Immunities Clause than it is to bring it under our established law of substantive due process? Is it easier to do it under privileges and immunities than it is under substantive due process?
It's easier in terms, perhaps, of the text and history, the original public understanding.
No, I'm not talking about whether the slaughterhouse cases were right or wrong. I'm saying, assuming we give the Privileges and Immunities Clause your definition, does that make it any easier to get the Second Amendment adopted with respect to the states?
Justice Scalia, I suppose the answer to that would be no, because —
And if the answer is no, why are you asking us to overrule 140 years of prior law when you can reach your result under substantive due process? I mean, unless you're bucking for a place on some law school faculty.
No. No. I've left law school some time ago, and this is not an attempt to
Well,
return.
I mean, what you argue is the darling of the professoriate, for sure, but it's also contrary to 140 years of our jurisprudence. Why do you want to undertake that burden instead of just arguing substantive due process, which, as much as I think it's wrong, even I have acquiesced in it?
Justice Scalia, we would be extremely happy if the Court reverses the lower court based on the substantive due process theory that